Nyamia Domina Unswe.
Ah,
okay. Edi kind my kind with statement I wish you, I don't know the decision of the Court of Appeal and then eba as a shock to you and
no friendly I said because yes, was quite surprising to me. Surprising to me because this is not the first time I saw cases with financial law cases here. Yeah, from the 2001. Now, Supreme Court of Ghana, Court of Appeal, and the High Court, they have firmly established all the principles regarding them. So, they are two who send financial law cases here, woefully causing the damage to public property, what it is about any procurement breaches. And I have evidence that I leave your court for. That case also has been open to the public. The whole public follow case. They haven't seen a case in echo evidence reality. And so far, the lady what Boy Abofuka Rebecca cogent evidence. I share court said clearly was financial loss in the case. The house of financial loss established. The financial loss was established when
too bad. Yes.
It was established time Ghana government imported ambulances into Ghana 2014. And like I said, if I not even ambulances, to import vehicles, or Rebecca cars. Into vehicles, I appointed because Minister for Health now or office at the time I appointed imported vehicles into the country. Or no answer letters, not one, but at least two. HSA vehicles were ordinary vans and which are not fit for purpose. As I say, no ambulance, but no normal buses. And for example, Kalgana just structure. Now, apart from that, yes, just medical equipment are not any ambulances. I'll be cast because of that, ordinary vans. Even the kind of vehicles which were imported were contrary to what the agreement stipulated. Agreement specify particular vehicle as a for the purpose. I'm say 8311. 8309, I'm sorry. And we're importing here 8311. Apart from that, from the body, from the engine size to even the interior and other parts, other material parts of the vehicle were contrary to the specifications of the contract. Now, I will say later on medical equipment number. From December 2014 up to January 2017, NDC4 a free power. Now fix any part. And the reason is that the vehicles could not even be converted into ambulances. And the AM Namiko, where a report by the National Ambulance Service and Ministry of Health. But apart from the National Ambulance Service report, Ministry of Health consulted the authorized dealers in Mercedes-Benz because cars, Mercedes-Benz cars. No, my formal report in 2015 before NDC4 leave power said no, vehicles ain't been converted into umbrella. Forget about it. So over 2 years, the vehicles are not converted into ambulances. So it was not beyond doubt. Say, as for the financial laws that is established. Who says that question? When I say that question has been answered, was there financial loss? Financial laws established. The next question, I say, more answer. If we are a lawyer, now a judge. So, I charge you more. No year, I cost is financial loss. And that is what we call in law the causation. Establish the causation or the causal link between the act of the accused persons and the offense. Now, again, yes, show court to say, and yet first accused, no, now a deputy minister for finance at that time after forcing letters or Troy saying fine service else is not transactional, it should not have occurred or would not have materialized because Minister for Health at that time, from person supply ambulance, or trauma, no, no, only the unfunded son shares a juvenile. So, informal letters, not oral word. I because you've been a car and CC letters I attend in court. I say no on the transaction there. No. Apart from that, nobody in the Ministry of Health authorized this Ministry of Finance. Yeah, I already said import ambulances and they're going to service the LCs. Now, LCs is not just anything at all. LCs is with an agreement. Almost the vehicles shall be paid for through the establishment of letters of credit. Into LCs, no need to pay the form of payment for the vehicles. What I say?
Yes.
And I can't say obviously just security. It is a means of payment. If it's near just security, say how were the vehicles paid for? And indeed, all our witnesses were asked this question and they answered it. And the vehicles were paid for. Beside lawyers for the defense say, into how were the vehicles paid for? And the vehicles are free. The vehicles were paid for 2.39 million euros through letters of credit established. And the amount was drawn under the LCs. To get the point. So the question is, who authorized the settlement of the LCs? Again, the former deputy minister for finance, Dr. Forson. Clearly, that's the evidence. On the throne, 2 letters, dated 7th August and then 12th August 2014. After that, LCC established 18th August 2014. After that, ambulances, no, friends, big C for no more Dubai, almost supply. In the case, LCC now established ambulance and can supply. Do you get the point?
Yes.
Then, what is most curious and say, this is a contractor, and at the time I'm perform no contract in parallapse. Because the contract was signed in December 2011. And the contract now, no, December 2012, if my memory serves, I think December 2012. And if you look at the contract now, they had 11 months to deliver all the 200 ambulances. So from December 2012, it will take you up to November 2013. The contract is set performing. And by August now, more thoughts or letters of credit say ambulance. There was no contract performed. The time for performance of the contract had lapsed. It is from again to this is a contractor which is being entered into with the company based in Dubai. It's not a foreign business agreement. It's an international business agreement. And clearly, by laws organizing parliament and parliament and who now all deputy minister for finance, one has your own. What I say, yes, services letters of credit. For us, the point I'm making is there. Clearly, we had established a case against the accused persons. It was not in doubt. The accused persons were supposed to open their defense. They had indeed started opening their defense. The first accused person had closed his case. He brought witnesses on the certain bao, certain person authorized or document to him, also need document via. There's nothing on record by which he authorized the transaction. Other witnesses were called. Omar Klusi, Jakpa, third accused, also in the course of opening his defense. Then, after the blue, Godfred Odame comes up with this ruling. Of course, it was an appeal against the ruling on the submission of notice, which had been made by the trial judge in March 2023.
Yeah.
It's appealing that on the terminal and then that is it. That is why I am surprised by the outcome. But of course, it's not the end of it. I mean, Obi, when we say this is not the first setback in my effort to prosecute these financial crimes. Even opening case in Pono had a setback. The same submission of no case ruling, which was made by the former judge, I think Justice Konyanuga, Supreme Court first, surprisingly, Supreme Court ruling by Justice Waniga. I had to go and review. Now review, I had success on review, and the ruling was reversed. The Samba High Court said we should have opening defense. Then there was an application made, and the trial judge then stated said we have to start afresh. We have to start de novo because that's not Justice Waniga Wareta again under strange ruling. It was one that really was also against all reasonableness. I took it in my stride and I appealed against it to the Court of Appeal. And I succeeded. It just as is normal, just as me I'm used to know. I still appeal against this one. And I'm very sure that it will be set aside. Because really the ruling there mean in my respectful view most unreasonable, and it goes against the essence of all the authorities on causing financial loss. Indeed, there is no case as clear as this one. There's no case in which the ingredients of causing financial loss have been established in as lucid a manner as this one.
But Cousins, how kind the Court of Appeal decision now, Minya be 125 pages. But I was just taking a cursory look. So I share because a majority in Dusha a 2-1.
Yes.
So we'll share the first justice our two justice akabuafo paragraphs 149 150 151 of the decision now okawa 149 or say the evidence further establishes that the ambulances were initially parked at the forecourt of the State House, but they were moved to the Air Force Base at Burma Camp by the National Ambulance Service at the direction of the Ministry of Health sometime in November 2015. Mr. Foster Ansong Brijan, PW1, who testified on 31st May 2022 said, quote, looking at the time we parked them there, the current state, the vehicles have actually deteriorated, unquote. 150 or say, my lords, if the above is accurate, in my respectful opinion, it defies logic that Jakpa at business, agent of the supplier Big C, would be charged with causing financial loss to the state based on the fact in the record of appeal when the plan put in place to rectify the defect of the ambulances to enable their use has not been implemented because the government failed to meet its obligations under the roadmap agreed to in 2016. In any event, that roadmap leading to the shipment of the parts to Tema Port was agreed upon between the Ministry of Health and Big C, not with Jakpa at business. So it is not clear why Jakpa at business would be asked, quote, to go and pay and clear the item to rectify the anomalies on the ambulances, unquote. As a corollary but to the foregoing, it bears mentioning that if there are vehicles, even if deficient in certain requisite parts, parked in Ghana, an action plan in place between the MOH and the supplier Big C to rectify the deficiencies and additional parts or accessories in storage at Tema Port for the said rectification, then there is a need to reassess the quantum of the alleged loss, a factor that impacts the case against all the accused in this case, and calling into question the maturation of the charges preferred against the accused persons. It is essentially, the justice of the court of appeal.
Yes, I heard everything. But the point, the judge, with all respect, misses the point. The financial loss was caused not because the vehicles were parked at the forecourt of the State House and were moved to a different location and were left to the vagaries of the weather. The financial loss was caused in the first place when the wrong specification of vehicles were even supplied. Number two, the financial loss was caused because the vehicles that came were not ambulances, were not fit for purpose, and indeed could not be converted into ambulance. And I've told you that indeed there was a report from Ministry of Health and National Ambulance Services which show that the vehicles that were supplied were so fundamentally defective that nothing could be done. And indeed, this report from the licensed dealers in Mercedes-Benz showed that the vehicles that were actually supplied could not be converted into ambulances. In this, would just because see one more 10 days to 100 years to 10 weeks exit material. In the first place, the vehicles should not have been supplied. Wrong specifications supplied, not fitted with the relevant equipment, indeed could not be converted into ambulances subsequently. And if indeed a meeting are converted into ambulances, from the part of ruling I read, this thing that you're talking about occurred in 2015.
Yes.
The movement. How come from 2015 now up to 2017, NDC for legal officer, they couldn't convert it into ambulances? How come they couldn't fix the equipment? Because it couldn't be converted into ambulances. And that is not based on the oral testimony, it's based on documentary evidence from the license dealers in Mercedes-Benz, which we are stated in evidence at the trial.
Then based on what?
No, but the point about the fact that even the court for appeal was split in the judgment,
yes,
supports my view. Say the judgment itself is not sacrosanct. Is not one that cannot be impeached, because even on the court for appeal, the court for appeal was divided. It was a majority decision, 2-1.
Yes.
And everything in my training and upbringing would dictate that such a judgment ought to be questioned. We have to test the soundness of the decision at the Supreme Court. Not just a matter of testing the soundness. For me, it defied, with all respect, every reason. Because, yes, the vehicles were supplied. Number one, the vehicles were wrong, were not the ones specified under the contract. Number two, the vehicles were bereft of all the necessary ingredients, as somebody would say, for one better expression, the necessary features of an ambulance. It didn't have all the equipment. Apart from that, they were defective. Even the engine capacity, the engine size that was set out in the agreement, the body and all that, all the interior parts were different from what was supposed to be supplied. Now, after that, more than 2 years, they could not be converted into ambulances because there's a report, technical report from those who deal in such vehicles, that those vehicles, with all respect, Ghana say, are useless because you can't convert them into ambulances. So, what again is a big deal? And as I said, so that's why I made the point there. You cannot have a much clearer case regarding financial laws than this matter.
Than this one. But now, me Busa Council say, based on what then would the Ministry of Health then agree with the suppliers on a roadmap to rectify, for which reason some parts were imported into this country? And you clearly heard the Court of Appeal judge Akabuafu make that point, say that roadmap was between the Ministry of Health and the suppliers. If they don't understand why Jakpa at business would be implicated in this matter.
So first and foremost,
yes,
even if this roadmap is valid, anything to go by, it's not after the fact. It's not after the wrong vehicles have been put into the country. It's not after the wrong specification and all the various breaches under the agreement have been committed. It's not also after payment has been made contrary to the laws of Ghana. Payment in favor of a company which did not have parental approval, even though they were supposed to have parental approval. Now, secondly, as I stated earlier on, which I'll repeat, indeed, that so-called arrangement to fix the ambulances could not be carried out because the vehicles should not be converted into ambulances. And it is not Godfred Odame saying it. It is as per the evidence that was stated at the trial. So the judges examined that particular evidence or they ignored it. If that evidence was ignored, then that's basis for us to have the decision set aside. And I do not think that there was an adequate assessment of the evidence of the prosecution from the judgment as I have considered it clearly. And if you look at the judgment, the dissenting opinion of Justice procurement, clearly it examined all the ingredients of the offense. It also examined the necessary material pieces of evidence that were tendered by the prosecution. And I think that is what is most important. So where, with all respect, one judge decides to look only at one version of the facts and which will support a certain conclusion, well, I think that it's up to us to question it on appeal. And I do this not because of any emotional attachment about the case and all. Let me say, I hold a very important office, Attorney General, Minister for Justice. I'm responsible for safeguarding the rule of law. And I'm responsible for ensuring that where there's any decision against the Republic, which is really a dangerous precedent, that decision ought to be questioned. Unfortunately, this is not the highest court of the land, it's the Court of Appeal. The highest court of the land is there, and it will be examined or to be composed by judges of 5 justices of the court of the Supreme Court. So I think that indeed, for the sake of ensuring that there's public accountability, upholding the rule of law, and in the interest of the fight against impunity, which is that if you are in public office, you cannot just do as you like. If one ministry responsible for a subject matter actually writes a letter saying that no, this transaction should not be proceeded with, and then another deputy minister for finance who is responsible for protecting the public purse, Minister of Finance, before they make a payment, during the process they go through, even I as Attorney General sitting here, when I saw them write letters for payments to be made, they will go through and question and I have to justify. So with the fact that you are the Minister of Finance, does not mean that you should ignore or disregard all the factors that you have to consider before you make payments. For that's actually the most important duty.
Yeah, but how about
the payment?
Counsel, how about the points? If there are any people to blame for what happened, it should be officers at the Ministry of Health, because the agreement essentially was between the Ministry of Health and Big C.
Right.
Jakpa and the Finance Ministry.
No problem. And the same Ministry of Health, as I've indicated to you, wrote saying that they did not want to proceed the transaction. And the same Ministry of Health never requested the Minister for Finance or the Deputy Minister for Finance to authorize the payments for the vehicles. And the vehicles, as I've indicated, were paid for with the LCs that were established consequent upon the authorization of the Deputy Minister for Finance, Dr. Forson. So it's as simple as that. Minister of Health that you're seeking to blame, they self-wrote, say no, this transaction, you shouldn't proceed with it. That they do not have money to establish any LCs. Then someone sitting somewhere in another ministry, Deputy Minister of Finance, right to request for payment to be made. And there's no doubt at all. That request for LCs to be established was what resulted in the payment. But if you look at the agreement, the payment was supposed to be made through the establishment of letters of credit, through LCs. There is no other means of payment. The payment was by LCs. So if you write asking for LCs to be established, what are you requesting to do? In order to request for payment to be made?
But would you also say, sir, subsequent to the letter from Sharia Ite, for the want of a better expression, the counter letter from the AG in the advice, in this case?
No, the Deputy Attorney General then actually wrote that they should comply with the terms of the contract.
Mm-hmm.
And the terms of the contract would have required that one, you ensure that there's pre-shipment inspection done. If they had carried out that pre-shipment inspection, they would have realized that the vehicles that were supposed to be supplied were contrary to the specifications under the agreement. Yet, the payment was made when there had been no such pre-shipment inspection. So if you are a Deputy Minister for Finance and there are terms set out in the agreement that you claim you are performing, and the Deputy Attorney General has advised that comply with the terms of the agreement, are you not going to check whether the agreement has been complied with? It's as simple as that.
In this case, no,
that is why in all these financial cases, a very important element is whether the officer in question was reckless or negligent. And indeed, complete negligence or recklessness is sufficient to actually show mens rea or the intention to commit the offense.
In this case, your understanding is the Deputy Minister of Finance then, for the reasons one find out if the terms have been complied with, pursuant to the advice of the Deputy AG, or omitted that element, of course, in financial laws, right? That's your argument.
Yeah, it's not only him, but all those who were involved with the commission of the offense. We had initially charged the then Chief Director, who had also written letters at that time, and who had actually made some false representations to the Public Procurement Board. So then the chief director, who was the second accused, actually or catch a PPA about Big C was the one which negotiated for the funding of the project. But it was not true. The funding that he was talking about was actually a Stanbic bank loan, which was never obtained. In fact, that Stanbic bank loan was even disregarded. And then the Deputy Minister of Finance, at forson, then authorized that they should pay for the vehicles out of the Ministry of Health account. So it's not only him. The second accused was charged, but it was Jakpa. I mean, he was very, very much unwell. He had kidney disorder. He had to flown to India. So we had no option but to discontinue against him. And then the person whose act also brought Big C into the picture. Big C supplied the vehicles person to the introduction of Jakpa, of Big C to the government of Ghana. The Minister for Health and all those public officials never knew about Big C. He brought Big C into it. And he even profited an amount as much as 700,000 euros after the 2.3 million euros paid. And Obi, how can it be reasonable that you tier for vehicles 2.3 or 2.37 million euros or 2.39 million, 2.3 million euros thereabout. Now Obi agents, middleman, or no, 700,000 euros. Anyway, this is Ghana.
Yes, Council, the other thing I may pay clarity on, your insistence, I remember during cross-examination, they said the former finance minister said Tepe entre evidence just on the order, no? You wanted to see something in writing?
Yes, because he himself even had admitted in cross-examination in matters bordering on withdrawals from the public purse, you always have to evidence it in writing. You can't authorize so being from government purse with nothing in writing. Is it possible? No. Even here, in this office.
Yeah, but forson signed for his boss, no?
No, that is not what I'm talking about. So he says that he authorized. No, every person here, I mean, in every ministry, so far as you know the minister, if you are writing, by convention, you write for the minister.
Sure.
You understand? So that for is immaterial, it's irrelevant. So the question is, and even in criminal law, various financial law cases that have been done in the past, clearly, authorities have to defend that the mere fact that you acted on the authority of your boss alone does not mean that you are extricated from liability. Two parties say, Obi, more as a danger. That's a 7 my deputy after Chiaba, no nice gentleman, penny was me. That's it. Wakoye Bibi, about attention. Oh, no, so agent and Swatino. You see, so I can instruct agents, so I can instruct Chiaba, so go and breach the procurement laws of the country. Now for Chiaba, he goes to breach the procurement laws of the country. Now you're charging out, so maybe my boss and strategy. So even if it is true, does that mean that you will not be liable? Clearly, that's poor reasoning. It's not really proper reasoning at all. The authorities are there. Is that in criminal law, with that kind of responsibility, they will not lie.
But the other thing so would be the parliamentary approval, because you made that point earlier. Yes. Is it the case if a contract between the Ministry of Health and a private company, or internationally, as per Article 181, was called Parliament for approval near there, say, why should the agent of that private company and a deputy minister of finance be held criminally liable?
So Obi,
yes.
The share part of the negligence and the recklessness I'm talking about.
Okay.
Say, right now, if I'm the attorney general, I'm supposed to review a document clearly between between government of Ghana and another foreign company, and it is quite many. We had say called Parliament. Now, my single Parliament because I have an interest in it. If in future Assembly National approval say indeed we said that panel because when you say financial laws, these are factors that you take into account. Whether it should have been so clear to you, said no, this one, I think I say, no, I say. Do you get the point I'm making? So that's the whole point. I mean, right now, Parliament of way, say, hey, this is you are going to Parliament. They be even an agreement that Admamenu, I think the money was refunded. To date, this is where they say, oh, you are going to Parliament, and he didn't go to Parliament, and he violated procurement laws when the money was even returned. What about this one? I mean, so I don't think that there's anything controversial about.
It doesn't matter. Council said the term sheet from Stanbic and there was a found the procurement. No, that one was approved by Parliament. No.
Yes, but that was what was used. They ignored it. They disregarded it, so it doesn't come in at all. The term sheet approved by Parliament was ignored in this transaction.